An important consideration when setting up a company is to figure out how it's going to be managed. The corporation is relatively simple because all corporations are managed by their board of directors. The directors can appoint officers who serve at the pleasure of the board of directors, but ultimately management responsibility rests with the board. Similarly, in a limited liability company, they can be managed by the members or they can be managed by a manager. And sometimes it's a single manager, or other times it's a board of managers. But regardless, whoever is managing that limited liability company or corporation, they're responsible for ultimately the management and control of whatever happens there. They can hire and fire officers in their discretion typically, but ultimately they have a responsibility to pay attention and to know what's happening and to deal with the affairs of the company. The governing documents for the company are going to set forth the procedures for noticing meetings, for how to elect the directors, how to appoint the officers, what their duties are, what the rights of the shareholders might be. In a limited liability company, it's very common to see restrictions on what the manager can do, and sometimes even in a corporation, limitations on what the board of directors is authorized to do. For example, do you need shareholder approval of certain actions, such as the ability to issue additional stock or create a new class or series of stock? Do you have the right to enter into contracts over a certain dollar amount? Does the board have authority to approve a merger or sale of all the assets with somebody else? Do they have a right to declare bankruptcy, liquidate the company, enter into a new line of business, or to change the tax status? All these kinds of things can be set forth in the governing documents for the company so that the rights and obligations of the various parties can be established from the beginning so it doesn't create conflicts down the road. These governing documents can also address things such as how to deal with a deadlock. What happens if the board is evenly divided? Does the status quo remain in effect, or do we put in a mechanism for breaking that deadlock in place? Whether it's you go to the shareholders for a vote, you go to a third-party neutral, one party may have the right to buy another one out. There's many different ways to try to address these situations, but they need to be set forth so that they're binding the parties from the beginning. Similarly, conflicts of interest are a good thing to address in these kinds of documents. If a director or officer or owner of a company is presented with a business opportunity, does he or she have a duty to present that to the company so the company can consider whether to do that? If in fact the company is going to have the right, it probably ought to set that forth in the procedures for how those things are going to be considered. Who's got a right to vote on it, and what kind of percentage approval is necessary. Similarly, these documents can discuss procedures for calling a meeting, for deciding whether the owners have rights to all the records of the company. Is there a right to review the financial statements, and does the company have a duty to audit those financials, or can it just present its own compilations of the financial statements? The important thing is these kinds of things can be customized, can be documented, and if they're thought through from the beginning, a lot of times conflicts and problems can be avoided.